Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what happens if you're arrested for OUI and your case is going to be heard in the Milford District Court. I've been handling cases out of Milford for years, so let me go through the process with you. First court date's going to be the arraignment. You'll enter a not guilty plea, get another date for what they call pretrial, and at the pretrial conference, we'll be able to get all the evidence, all the information to prepare your defense. Once we have all the evidence, then the next step of the process is either put it on for trial, resolve the case, or put it on for what's called a motion hearing. In some cases, there may be a legal issue that might make the case better for us for trial. For example, if you made some statements that are incriminating, I might be able to get those statements excluded from evidence. What I need to do is then set it up for a separate evidentiary hearing to eliminate or to argue to the judge that there was some constitutional violation that results in the judge suppressing the statements, meaning they won't be considered at trial. If there is no motion to suppress, or once the motion's done, then we put the case on for trial. In Milford, they don't do jury trials, so we'd keep the case in Milford. It's going to be a bench trial. If we want a jury trial, we have to transfer it to Worcester. I've done both. It depends on the case. It depends on different things, whether we want to keep the case in Milford or bring the case to Worcester for a jury trial. So once we discuss that, we'll elect a trial of some fashion. Now, while the case is going on, if you fail to breathalyzer, your license is suspended for 30 days. If you refuse, it's 6 months. So after the 30 days, if you took a breath test, you get your full license back, because many times we'll want to try to fight the admissibility of the breathalyzer evidence, see if they followed all the proper procedures. Now, to get all that evidence, it's going to take about 60 to 90 days. So you'll have your license back while we're fighting the case. However, if you resolve the case or found guilty, there would be an additional 45-day suspension. You wouldn't get credit for any of the 30 days you did for the breathalyzer failure. It would be a new 45-day suspension. The only time they run together is if you resolve a case within the 30 days. Whatever's left on the 30 days is forgiven. The downside of the shortened license law, so to speak, is that you don't have a chance to get all the evidence. But if it's a very strong case, in some cases I will recommend or at least explain to you further the option of resolving it fast to get back on the road quicker. That's something that sometimes people want to do if their boss or their job is really upset about the OUI, but is willing to work with you. And you might not want to tell them, in 6 months or 4 months about a possibility of another suspension. Trial outcomes are uncertain, but it'll depend on a lot of factors: the strength of the case, your situation with your family, your job, things like that. So we factor all that in deciding how to handle a case. Two people might have the same case. One person might not be in a situation based on their life where they can go to trial, where another person might be able to. Generally, in your best interest to try to fight these cases. We've had great success over the years getting breath tests excluded, winning cases on the merits, because keep in mind, it's a high standard of proof. To get from being arrested to proof beyond a reasonable doubt, there's a long way that the government has to go, because field sobriety tests, these are often unreliable, inaccurate. There's a lot of reasons why somebody may not be able to do a walk and turn or one-leg stand unrelated to alcohol. Could have been cold out. You could have medical conditions that affect your balance. So all these things could create doubt in the case. That's all we need is reasonable doubt. The burden of proof in a criminal case is to the highest degree of certainty. So that requires a lot of evidence. The jury and a judge would follow the same law, is instructed that it's not enough even if there's a strong probability. So in an OUI case, it's not enough to say you probably were under the influence, you might have been. The government needs a lot of evidence. And a lot of times their evidence isn't that significant. They'll say you missed some steps on the walk and turn, you're unsteady. But if there's not major observations, I think there's a good case, a good argument for reasonable doubt. And that's usually how I frame the cases in court, that if you don't have stumbling, staggering, you don't have major driving, you got a very, very close case. Could be they were under the influence, might not be. We don't really know. And if we get to that sort of point of uncertainty, a judge or jury should enter a finding of not guilty. Now, if you refused a breath test, the suspension's for 6 months. You might have read that you can appeal that. Don't appeal it, because your license will be suspended for longer. If you file an appeal with the RMV, they'll probably take out an immediate threat suspension. It'll take you off the road for a longer period of time. If If you're found not guilty prior to the 6 months, a judge may reinstate you on the refusal and you'll be able to get back on the road. The only way to get back on the road if there's a refusal is you would have to resolve the case, get a letter from your work to get a hardship license. So if you have court in Milford, feel free to call me. I've been handling cases in Milford for years. Glad to help you. Call, text anytime, 781-686-5924. My name is Mike DelSignore. My passion is helping people make the best decisions for themselves when charged with OUI.